allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
First order of business is a resolution request, Madrona Leach Field Replacement Project. Usually we don't have an action item on a work session, but we're making the exception for today because leach fields are important, and I think everybody here who probably sits at this table understands that they are.
Thanks for letting me squeeze in, you guys. Good evening. So tonight I'm presenting two resolutions to the board regarding the failed leach field at Madrona Elementary School. Due to the failure, a replacement waste treatment plant will be needed to install. This is going to be something similar to what was installed at Lincoln Savage a few years ago. I'm thinking it was 4 or 5 years ago at this point. So resolution number 4, I'm asking the board acting as the local contract review board to allow the exemptions to the bid requirements for the Madrona Elementary Leach Field Replacement Project. This exemption falls under ORS 279.080, and this resolution will designate Dave Valenzuela and or Casey Alderson as staff members authorized to approve bids and purchases during the emergency phase. This will allow the prompt execution of one or more contracts to remedy the resolution, to remedy the condition and prevent possible threats to both property, public safety, and local environment. So that's the first one. I don't know if you guys need to approve that one.
I make a motion that we approve this, your
Exemption.
how would we
Resolution.
phrase that? The emergency resolution is stated.
Thank you.
Is there any,
I'll second.
Okay.
Discussion?
Yeah, let's have some discussion on this.
Sorry.
is there any orders of magnitude and cost? I mean, is this going to be $1, $1 million, or does anybody know yet?
Rough estimates right now are around $550,000, and that's where my next resolution will come into play as well.
Sorry, I got ahead.
No, you're good.
Voting.
Okay, all in favor of the resolution for designating Mr. Valenzuela or Mr. Alderson as the authorized to approve the bids?
Aye.
Aye.
Aye. Aye.
Thank you. Resolution number 5. This is to transfer no more than $250,000 from the general fund contingency, and along with no more than $300,000 from the self-insurance fund contingency to the district's capital fund, revenue 400 for the Madrona Elementary Leach Field Replacement Project.
Do I have a motion?
I'll make a motion to appropriate those funds as directed.
And I second that.
Any discussion?
This seems like it was, I don't know if it's a similar failure to what we had at Lincoln Savage, but I feel like this is similar in magnitude to what that cost.
And the cost of addressing it, and we have to do it quickly because of EPA regulations that could cost us a lot more.
We need to do
So
it.
it's very wise that we address it quickly and cheaply as
Yes.
possible.
Yes.
Is there any estimate, a time estimate? Is this going to take days, weeks, months?
A lot of it depends on DEQ.
The EQ has to approve the design, but they've already approved the design across the street, and so we're going to be using the similar design and the same contractor. This contractor that performed this work at Lincoln Savage was by far the lowest bid last time we went out to do this.
Okay.
Thanks, Dave.
All right. Any other discussion? I have a motion and a second. All in favor, say aye.
Aye.
Aye. Motion carries. Thank you very much.
Thank you, guys.
I was going to say it's a shitty situation.
No. I was going to say next time, don't break it.
Well, it's 65 years old. It's wore out.
All right, up next is Intellectual Freedom Committee presentation, and I assume that's Miss Emily O'Neill.
Yes, and it looks like it says my video cannot start because the host disabled it. I think we had a little glitch there for a minute. There we go. Perfect. Perfect. Okay, can everyone see and hear me?
Yes.
Yep,
All
you're on.
right, I'm going to go ahead and start my slides and take you through a presentation on intellectual freedom. I know you all have been experiencing some questions about books and book selection in your libraries, so I just want to take you through some information to help guide you as you work your way through these discussions. So the first thing is sharing who I am. So my name's Emily O'Neill, and I am part of the Intellectual Freedom Committee. I've been on that committee for the last 5 years. That committee is part of the Oregon Library Association. I have also chaired that committee for most of that time. I just stepped off chairing here in September of 2024. I have also attended a specialized program from the American Library Association put on by their lawyers and legal team from Harvard Law to provide legal training to libraries and librarians and folks of community need and interest, such as this, to address any sort of questions that come up regarding law and libraries. Because of all that work, I am your Oregon Librarian of the Year, and I am also a librarian myself. I work in Deschutes County as the Technical Services and Collection Management Manager here in Bend. So the first thing I want to tell you is I've just mentioned the law about 5 times in my introduction. I am not a lawyer, and this is not legal advice. It is required of me to tell you that. I am allowed to give legal information, but if you need legal advice, you should contact a practicing attorney. And I would like to add a practicing attorney on the type of law that you're most interested in learning about. So in this case, if you have questions about intellectual freedom, I would suggest talking to a civil liberties lawyer, a constitutional lawyer, or somebody that specializes in cases around free speech. So what is intellectual freedom? The big definition is that intellectual freedom encompasses the freedom to hold, receive, and circulate ideas without restriction. It is viewed as an integral component of a democratic society. Intellectual freedom protects an individual's rights to access, explore, consider, and express ideas and information as the basis of a self-governing, well-informed citizenry. So that's the definition, but let me tell you that that is not something that anybody really attaches to. That isn't something that really explains what intellectual freedom is. So the way I like to define intellectual freedom is I like to reverse engineer those words and tell you it is your freedom of your own intellect. It is your freedom to unrestricted access to information and ideas. It's your freedom to decide what to read, what to learn, and how to learn it. And it's your freedom to think and choose and get information and ingest it. But the most important part is that it is a constitutional right. So it also is one of your most important civil liberties given to you under the First Amendment of the United States, and it is protected constitutionally. So people often question how it is protected constitutionally. So civil liberties, basal foundation setting through years and years of constitutional precedent. So when a constitutional question is brought forward to the court system, the court systems will make a decision on what that means. Ultimately, those decisions go to our highest court, which of course is our Supreme Court. And within each of those decisions, we get precedent that helps us make that decision for future cases that come forward. So through the precedent in the court systems, freedom of speech, which is one of your First Amendment rights, courts have held that in order to have freedom of speech, you have to have freedom of informed speech. Courts have then held that in order to have freedom of informed speech, you have to have freedom of information. Courts have then held in order to have freedom of information, you have to have free and open access to that information, which is where libraries are now immediately tied to your First Amendment right of freedom of speech. The precedent that we're holding to currently comes from the Kramer versus Bureau of Police for the town of Morrison, where the court opinion in that case said freedom of speech includes the right to receive speech. And likewise, courts have held that libraries are a quintessential locus of the receipt of information according to the Third Court of Appeals. So now that we know that libraries are part of a freedom of speech, the question often comes up of, well, aren't there areas of speech that are not protected? So we've all heard, freedom of speech is not absolute. You can't say anything. Not everything is accepted in our court system. So what exactly are the things that our court system has said that you cannot say or that is not protected under that freedom of speech umbrella? And ultimately, the courts have been very, very narrow in what those exceptions. By and large, our court systems have continued to uphold freedom of speech as one of the most important, and the number of restrictions on that First Amendment right are very few. But some of them absolutely apply to the conversations that libraries are having about content in libraries. So the first one that applies directly to this conversation is the question of the obscenity. So to be clear, there is not a legal definition of pornography. We are not talking about pornography. Courts have said repeatedly that that is too subjective of a term and not something that they can define clearly. So when courts are looking at the content of material, they're specifically pulling up the obscenity law. So the obscenity law is defined through the court system. So the first thing I have to say is that I don't get to decide what is obscene. None of the individuals in that room get to define what is obscene. The only person that can decide whether or not something is obscene is through a court process. So a judge or jury would get to decide what is obscene and what is not obscene. When that court is deciding whether or not something is obscene, they're going to be using what is called the Miller test. So the Miller test is a 3-pronged test that requires all 3 of these elements to be true in order for something to be obscene. So these are and statements. The first is that whether the average group person applying contemporary community standards would find that work taken as a whole appeals to indecent interests. Broken down, that the contemporary community standards legally is defined as a nationwide standard. So that wouldn't be a standard for the Grants Pass area or Oregon as a whole. That would be defined as a country, our community standards are such. And that they work as a whole, so not taken in parts, not taken in pieces, not taken out of context, but the entirety of that work appeals to indecent interest. So that's prong number 1. Prong number 2 is whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by applicable state law. So under the obscenity law, the material must be in sexual content. So if the concern is that it's vulgar or has bad language or violence, the laws say that that's not obscene. The only thing that can be defined as obscene is sexual content. And then the third, if the first 2 are true, the third is that whether that work, again, taken as a whole, lacks any literary, artistic, political, or scientific value. So again, they've purposely defined this as the work as a whole rather than taking bits and passages out of context. So that's the Miller test. But then the question comes up, well, what about children? What about minors? So the courts have taken the Miller test and have applied a second legal test, which is called the harmful to minors test. So it takes that same three-pronged test of whether or not something is offensive based off of those three elements. And then it says, is that harmful to the oldest of minors? So under our legal umbrella, we only have one definition of minors. It's 0 to 17. So anyone 18 and older is an adult. Anyone 17 and under is a minor. So in order to do a legal test, you have to base it off of the oldest of those minors so that you aren't infringing on the rights of that oldest minor. Essentially, if something is harmful to a 7-year-old, but not a 17-year-old, it would still pass as non-obscene because that 17-year-old still has access to those materials. So that's thing number one that is not protected under freedom of speech. The second thing that is not protected under freedom of speech is child pornography. So again, a reminder that there is no legal definition of pornography as a whole, but there is a legal definition, of course, of child pornography. Child pornography is defined as any visual depiction of sexually explicit content involving a minor. The visual depiction is defined as a photograph, video, digital image, underdeveloped film, computer-generated images indistinguishable from an actual minor. So the material has to actually include an actual child. The law specifically says that visual depictions does not include illustrations, drawings, or passages in books. So anything within a book itself, unless it is an actual visual depiction, would not fall under the child pornography law. The last few that I want to call out is defamation and slander. Obviously, you cannot say false things about an individual in the hopes of defaming their name knowingly. False advertising is an interesting one, and it does apply to schools and materials in that in order for a material to get its what is called intended audience of the work, it goes through a legal process. So the intended audience of the work is the age that we choose that is identified on the material for that material. So who is the audience for that material? So that is first created by the author. Who did the author create that material for? Once that author has identified the age bracket for that work, it goes to their publishers, and the publishers confirm or deny that. Then the publishers give that work to professional reviewers who are librarians, teachers, other writers, other publishers across the country to both affirm or deny that intended audience of that work. Does that work actually sell to that correct age bracket? Then that goes to the publishing agency's legal team to confirm that when they sell that item to that intended audience, that they will not face a lawsuit for false advertising. So when librarians look at what age a book is intended for, we're looking at that intended audience of the work, and that has already gone through a legal review. And then the last are fighting words. Fighting words are materials that incite immediate and imminent lawless action. This is the one that you hear about all the time that says you can't yell fire in a crowded movie theater. The reason on that is that people will run out of a dark space that often has stairs and they could get physically injured in that action. Yelling that could cause immediate harm to the individuals in that space. So the legal framework for all of this for schools comes largely from the PICO case. It's called the Island Trees School District versus PICO. And ultimately, the PICO case has said that First Amendment rights in school content and the right to receive information is a corollary of that First Amendment. So essentially tying those First Amendment rights to students in schools. It says that all students have equitable access to library facilities, resources, and instructional programs. It says that intellectual freedom is fostered by educating students in the use of critical thinking skills and empowering them to pursue free inquiry responsibly and independently. It also says that members of the school community involved in the collection development process may employ educational criteria or select resources unfettered by their personal, political, social, or religious views. That students and educators served by the school library have access to resources and services free of constraints resulting from personal, partisanal, or doctrinal disapproval, and that school librarians resist efforts by individuals or groups to define what is appropriate for all students or teachers to read, hear, view, or access regardless of technology format and the methods of delivery. I'm going to skip this slide because I want to make sure we get to the laws here in Oregon and we can come back to that. Ultimately, there are types of censorship activities that have happened in schools across the country, especially recently, and each of these leaves the library or that school up for the possibility of a lawsuit, ultimately. So these are types of censorship activities that you should be aware of that could open the district up and the library up for legal backlash. Among those would be imposing age, grade level, or reading level restrictions on the use of resources. An additional one would be limiting the use of interlibrary loan or access to electronic information. It would include charging fees for information in specific formats or topics, assigning rating systems to the materials, requiring permission from parents or teachers to access choice reading materials, establishing restricted shelves or closed collections for choice reading materials, and then labeling the materials in a way that would discourage use of the material. So let's look at the laws specifically to schools and access to materials and school boards. So the first one came out in 1976, and it was the Menarsini case. The Menarsini case specifically came about because school board members wanted to remove books from the curriculum and the school library. In that case, the courts ruled that boards could determine what books were taught in the regarding curriculum, but removing the books from the library would infringe on the students' First Amendment rights, as students have the right to receive information. It's the difference between curriculum and choice reading. They also stated that a library is a place of voluntary inquiry and a storehouse of knowledge. The second case, so after the Menarsini case, the first and only case that has ever gone to the Supreme Court was the Board of Education versus PICO in 1982. In the Board of Education versus PICO, the courts were ultimately addressing whether or not a school board has the authority to remove books from library shelves. In a 5-4 decision, the Supreme Court held that the school board's removal of books violated the students' First Amendment rights. And specifically, this comes from the court opinion. The courts acknowledge that school boards have a legitimate interest in selecting educational materials. They should ensure that the materials align with the educational missions and meet the needs of the students. But that authority is not absolute. The school boards must work within the boundaries of the First Amendment. The majority held that school boards can consider the educational value of books, but they cannot remove books just because they disagree with the ideas expressed in them. Justice Brennan further noted that schools play a crucial role in exposing students to many ideas and opinions, and that fostering critical thinking and promoting intellectual development. Removing books based off of subjective judgments would hinder this educational purpose. So the question comes up, what if an administrator or public school supports the removal of books without going through a board-approved challenge or removal process? Well, again, courts require plaintiffs challenging the removal of materials to have legal standing. Ultimately, legal standing is showing that they had a reason to bring that injury forward and that there was an actual injury that occurred. In this case, current students in the school would have legal standing to challenge the removal in court because the removal violates their constitutional right to receive information if the removal was based off of a disagreement with the view expressed in the books. So what this is saying is courts have held that the failure to follow your procedures of evidence is unconstitutional, and in this case would be unconstitutional, and that the student would have standing to bring forward a lawsuit should a school board bypass their approved challenge process. Can a school library restrict access to materials behind the desk or with parents' permission? Courts have held that any burden on the exercise of the First Amendment rights is unconstitutional if the government cannot justify the restriction based off of applicable legal test. The court case for this one comes from 2003, where courts held that placing books, Harry Potter books, on a restricted shelf with parent permission only violated the constitutional rights of the students challenging this restriction. What that means here in Oregon is that there is an OAR specific to parental rights. And the OAR says that content, it is the Oregon Department of Education affirms the right to determine content that is not appropriate for their child and to request an exemption for their child from instructional activities that involve content that is against their religious beliefs or disabilities. So the OAR specifically says that parents have a right for a religious exemption in educational and instructional activities, but that is ultimately where that definition ends. So when it goes to a school, a library, when we're talking about library materials, ultimately parents have the right to request to review materials through a formal request for reconsideration process. And the Oregon School Board Association has updated those policies and processes as of November 2024 to help guide in setting that up. Oregon law has additionally said in ORS 329.045 that textbooks and other instructional materials must contribute to the development of identities that are under our protected classes. So making sure that instructional materials share the lived experiences of the Native Americans, American, Asian, Pacific Island, Chicano, Latino, Middle Eastern, women, people with disabilities, immigrants and refugees, and those that are lesbian, gay, bisexual, or transgender, and that these standards do apply to all educational activities as outlined in Division 22, such as school library materials. We also have OAR 581-021-0045, which prohibits discrimination in schools, specifically saying that curriculum must also uphold the rights of those that fall under, again, our anti-discrimination protected classes. So curriculum should include materials that share the lived experience from those that have age, disability, gender identity, national origin, race, color, marital sex, religion, sex, and sexual orientation. This also aligns with federal laws, Title VII and Title IX. Lastly, from OAR 581-022-2050, it requires that each school district adapt a child sexual abuse prevention program and that they include sexual education materials with a minimum of 4 lessons per year. The OAR specifically says that instructional and material must be age appropriate, medically accurate, and not shame or fear based, must include LGBTQIA and build upon itself. And again, this requirement does attach to school libraries under the Division 22, saying that compliance is across all educational activities. Ultimately, I'm here to remind you that how important those policies are. So you want to make sure that you have policies that are in place for handling materials challenges. These policies are there to create continuity in district operations and reduce ambiguity and confusion. So when a question comes up, you would know exactly what your process is. And it helps the public know what that process is. But ultimately, the purpose of that process is to be as objective as possible. When you're objective and clearly defined from the start, this helps disarm critics, as unfounded accusations seldom prevail when the district's operations are based on policy and procedure that reflect thorough research, sound judgment, and careful planning, and ultimately with legal consultation. It will help keep you from, in the case of lawsuits regarding the enforcement of these policies, to avoid being subjective and instead as objective as possible. When looking at your policies, things to keep in mind is you need objective language. You need to make sure things are clearly worded. You want to have systematic processes, clearly define the roles, ultimately clearly assign the decision makers. And my most favorite part of this is make sure that all policies are signed off by legal counsel and have gone through an intellectual freedom and First Amendment review before adopting. I do that because lawsuits are happening all over the country. This particular slide could probably be about 15 slides of different lawsuits that are happening as it relates to the removal of materials in libraries across the country. So ultimately, again, this is not legal advice, just legal information, but in breaking laws, individuals could feasibly have claim injury, and pull forward a lawsuit that could be very costly should laws not be followed. And we're here to help. So again, the Intellectual Freedom Committee is here to help respond to challenges, prepare you for challenges, and answer any questions that you have that come up. So I'm going to stop my slides and see how I can help answer any questions.
All right. Any questions for Emily? Thank
Sure.
you, Emily, by the way, for the
Sure,
presentation.
Emily. This is Pat Kelly. What does lack serious literary content actually mean? Are there cases that define it? We have a book that is R-rated. The Courier, very liberal paper, defined a chapter as raunchy. So I can understand, and I would define it as raunchy, and it's near X. It's in the middle of a book that otherwise is clearly not Shakespeare. So when we go to the definition of whether it's obscenity, and it says lacks serious literary content, how do we deal with that?
Yeah, I mean, that's very complicated. And, you know, in law language, they always say it depends, or, I'll give you a possible answer. Ultimately, when I have asked the lawyers that have trained me through that Law for Libraries program, if they can identify any books that have ever been found to not pass the Miller test, they couldn't tell me of one. So, for example, even Hustler magazine, Playboy magazine, Penthouse, when they have been challenged in courts, they have been found to have artistic, literary, or value because of the articles that were written in them. So it is very, very difficult.
I know that's for adults, but
legal
for children, it might be a lesser standard, or is that the standard for children also?
The Miller test is still the standard for children under that harmful to minors clause. So if it's got literary value for a 17-year-old, it would pass.
Okay, so you're saying 17 and under. Our district does actually 18 and under if you do our thing. And I don't care about 18-year-olds. I care about 8th graders and 9th graders and 10th graders. I have a book that's an obvious R-rated book. You're saying I have to provide access to these books to everybody under 17 in our school system.
I'm saying that if you were to bring that to a court, they would apply the Miller test and would likely find it to have literary value to a 17-year-old. But I don't get to make that decision. You don't get to make that decision. That's the legal test that you would have to prove if you wanted to be in compliance with constitutional law.
I happen to have been around for a while, and I remember when men used to say, I read Playboy for the articles. But to be honest, they had good articles. Are you saying that if we put Playboy magazines, which now have reproduced nude pictures of women, in our libraries, we have to keep it?
I would say no. That what I would ultimately say is that the way that materials make their way into a library is through the selection criteria that are outlined in your collection development policy. That selection criteria will likely include if you recall the false advertising statement, will include a statement of the intended audience of the work. So in looking at the intended audience of the work, the things that make their way into a school library should fit the intended audience of the age bracket of which you are serving.
So if we have explicit sex in a book, my favorite part was the crinkling of the condoms as they were opened. And my library staff says, oh, that's great for a 17-year-old. It automatically goes into our library, and everybody from first grade until 12th grade can have access to it, because I don't think we restrict access between libraries in our school district.
Correct. Yeah. And again, this is ultimately where the law, like, again, I can't tell you what to do. I can't tell you what legal advice is, but what the law would say is that in order to bring an item into your library, you would want to make sure that it is following selection criteria that are outlined in your collection development policy, and that criteria is upholding the intellectual rights of the oldest of minors.
Who
so if
that
that book has an
in this
intended
selection
audience
committee?
Of a 17-year-old, it would, and otherwise fits your selection material criteria, it would have value in your school library. And if it were challenged legally, that would be the legal test they would be looking at.
So who is it that, see, I'm always going back to the next level. Who gets to set those policies? Where do these policies come out of the air? I'm not being, I'm always inquisitive. But
questions are lovely.
There's this fine policy that we have set, and we set a policy that we don't want books with explicit sex in them containing the entire chapter 7 because we don't see it has value for our students. Then we can ban the book.
I would advise against that. So ultimately, the policy is there are several policies that I mentioned that came out of Oregon School Board Association, and that helps identify what to do when there's a request for reconsideration and how to identify who the decision makers are for content. So for materials in libraries, the selection criteria is identified by the district librarian through their Masters of Library Science education. So the district librarian would set the selection criteria objectively to fit the education values of your school district.
I have to trust in their discretion, therefore the board cannot review their discretion.
Based off of the PICO case, it would be questionable whether or not the board has that authority.
Okay, so libraries lend out things more than just books. R-rated movies are restricted outside of the school district for people's, I think it's 18 and under. without parental permission. So we can buy R-rated movies that are pretty close to X, and we can put them in our library. And if it meets the librarian's restrictions or values or whatever they're saying, we have to keep it there and allow everybody from first grade till 12th grade to have access to the R-rated books or R-rated movies that they can't see outside of the school system.
So there's a couple of things there. So first, I want to again clarify that the selection criteria as identified by the district librarian is objective, that aligns with the educational values and goals of the district. So it's not subjective, and it isn't something that you would be opinion based or ethically based. It would be objectively based. For what you're defining as R-rated movies. So R-rated movies, that comes from the Motion Pictures Association, and that rating system is actually deeply flawed and is based largely actually on how they're going to make money. So identifying if this book or this movie will sell better to an audience as a rated R versus a PG-13. So just there's a lot of concerns and questions with that rating system. Ultimately, it is it is up to the movie theater to set their decisions on whether or not a child is allowed into those movies or not.
Is an excellent movie.
What was that?
The Godfather's an excellent movie. Actually, I think all three sequels are, but it has explicit sex in them.
Yeah, and so then again, that comes down to the intended audience of the work, right? So when the intended audience of the work is an adult,
sex in the book, can we put because the book we're disturbed about has explicit sex and it doesn't constitute the entire work taken as a whole, means I got to allow that book. Do I have to allow the Godfathers for in our library to access people who are ninth graders?
Yeah, so again, it's the intended audience of the work, right? So the intended audience of the work for The Godfather is for adults. And so you would decide whether or not that material is fitting the age bracket of the materials that you're selecting for.
And it's actually pretty raunchy. That's intended. I don't care what the author says. I mean, the author may say of The Godfather, this is a great piece of cinematic work, which it is, and we should show it to everybody. Am I going by his intent or objectively what the intent of the movie, and can that even be determined?
I think that you're getting stuck on a Godfather example, and I'm trying to answer it, but the answer is going to be the same. It's exactly a
corollary of our book example.
Well, I understand that, but this cannot be an emotional reaction. This cannot be an emotional conversation. This has to be based off of what the law says. And the best that I can give you is the same answer, is that the decisions for the materials that make their way into your library should be objectively based off of selection criteria that are given by master's level district librarians that you've hired to do that job, and that some of that criteria is going to be the intended audience of the work that attaches to the educational values and goals of your district.
I do sound irritated. Because I am an attorney. If I haven't kind of slipped that in along the way. So what I'm given here is very loose, very subjective standards that essentially allow virtually everything in if our library committee approves it, and the board can't review it, and we just have to take it as a community.
Ultimately, I would say that it's less loose than it feels, and that I would recommend, especially since you are an attorney, I'll make sure that you have these slides and to go back and read the full legal casework so that you can have those answers. But if there are any questions about how to apply those legal laws, that's a really good time to bring in a constitutional lawyer to review.
So if we want to challenge it, or somebody wants to challenge it, I'm not going to, because I'm not going to spend the money. Do we bring that to federal court or state court?
Ultimately, what would happen if materials were removed that a student felt was a violation of their constitutional rights, they would have a right to sue the school district over a constitutional violation, and would likely be backed by probably the ACLU of Oregon, as well as likely the publishing house and or the author of the material that has been essentially censored at the school. So that would be up to the student to press charges about the removal, or to file a lawsuit
You could do
about the removal of
motion,
materials.
excuse me.
If you want to change the law, you would have to find some area where you have legal injury in fact and sue. So you would have to bring forward a lawsuit and hope
Would
that
be
the
a
law would
motion
change.
for declaratory-
Ultimately, the
it'd be a
Supreme
suit-
Court has continued to follow the precedent that has been set
It'd
from
be
courts over the last
a
30
suit for
years.
declaratory relief is how we would go, but we're going to be done that way. And we could ask the court for an opinion without involving actually an active defendant. But let us go one more step, because I'm going to be mean here. These standards are scaring the hell out of my public. Grants Pass, Josephine County, Southern Oregon is not Portland. I have Mormon students, I know Church of Latter-day Saints is the appropriate way to say it, have always come, I happen to be Catholic, but come into me and complain of what their children see and hear at school. And you are alienating our public from our own school systems and making our own systems non-viable financially. Do you know what you're doing?
Doing anything. I'm sharing what the law says.
No, I don't
and
think
giving
so,
you
but we'll go
information
on with
for
this.
you to decide what to do with.
I believe that we have a very tight budget. Can we eliminate our library?
I can't give you, I am not legally versed enough to be able to answer that. I would definitely bring that to a lawyer.
Okay, so anybody have any, this is terrible, I sound like a court, anybody have any further questions?
I thought you'd never ask.
Thank you.
One thing that I wondered as you gave this presentation about some of the legal boundaries is if a board acted and took.
Oh, I think you just lost your mic.
Oh, it's on. Can you not hear me?
I heard you and then it just went away.
Okay,
Just
let me try again. If a board met and decided to take action to remove books from our library, and we were knowingly in violation of state or federal law, could board members be held liable individually or personally for those actions, or would it be the district's liability?
That's a great question for a lawyer.
think it's
My best guess is that anybody can be sued for anything, and that they would likely do a wide swath of the lawsuit and try and take as big an action as they could. So you could feasibly be named individually as parties to the lawsuit, but that would be a really good question for a lawyer.
Would you give essentially X-rated material to your 9-year-old daughter?
That's, again, an ethical decision. I'm not here to talk about ethics. I'm here to talk
But you're
about the law.
talking about the ethics where the school would have to do this. If they're, can parents object into categories as except for if I give if a parent writes in and I said I don't want my child exposed in the library to any material that contains X, Y, Z, R. And do they have to specify each book, or can they use categories to opt out?
Well, that's a good question. So ultimately, the legal rule for monitoring the use of library materials is called en loco parentis, which is that we don't serve in replacement of the parent. So the parent is the one that gets to make the ultimate decisions about what their child reads or is exposed to in a library. And typically what that means is that the parent will set rules within their own household on how that child is allowed to use a library and the resources that child is allowed to access within their own home, within their own unit.
But not within the school.
I do know of some libraries that have gone a route of a certain form that a parent would have to fill out that would identify specific titles that their child is not allowed to check out. I do think that could be questioned in court. But again, I can't give you legal advice. That would be up to the individual library and the individual child to, if that child felt like their rights were being violated, they could feasibly move forward with a suit.
I'm just gonna tell you the truth. You're making a hell of an argument for private schools. And if you want public schools to continue, maybe the foundation you belong to should set better standards instead of allowing eighth graders to actually, without their parents' approval, access sexually explicit books. And then.
But again, I didn't set any standards. I'm just sharing legal information.
That's just
It's
an
your
excuse.
responsibility to make
You're this
known.
organization. Do you know how bad this is to our public?
It's your responsibility.
I'm not a lawyer. I didn't set the precedent.
It's your
I'm just-
responsibility
You don't care,
to
though.
make it known what is accessible to the child, to let the parents know what the children have access to. That's your responsibility.
That's the parent's responsibility to decide what their child is allowed to read.
Yes.
So moving this into maybe a little bit more of a functional conversation in terms of our district and how we might be able to move forward. There's a few things that I'm kind of understanding from your presentation. I know we need to digest this as a board, but kind of what I heard is it's very difficult once something makes it into the library for us to legally remove that. However, our best chance or our best actions could be very stringent or careful observation or guidance of what's coming into the library. Is that a fair assessment to make?
I would be very careful with that. Ultimately, it's restriction of access to freely to information that would fall under that child's or that minor's intellectual freedom rights. So whether the material is removed or never selected, that's still being censored from their right to information. So that wouldn't necessarily solve the concern. Ultimately, the materials should, again, fit a very objective collection development policy. And as long as the policy is objective, materials should not be restricted based off of any sort of subjective, personal, ethical, clearly undefined reasons that would be outside of that collection development policy.
So what I gather from you, we can't restrict anything for virtually any reason going into a library if our librarian says it's okay and she follows incredibly loose standards.
Well, hopefully they're not loose standards. Again, hopefully they're objectively defined in a collection development policy, as long as they adhere to the educational values of the district.
Sex, and that would be included in your list of things that are allowed.
Yeah, I mean, sex education is required through
This is
that
not
OAR
sex
that I
education.
stated in my
This is
presentation.
not sex education. This is genuine, raunchy, I would consider it pornography, and I'm a pretty tough guy, and I've seen a lot of things. And it's in chapter 11, I'm just make up a name, in a book. Why in God's name, forget God, do I want to expose minors to this?
And again, that's where you're looking at the work as a whole, right? Because that work could have other values within it outside of that chapter 11.
That you think that doesn't outweigh the negative value of the explicit chapter, just as long as it has something else in it we have to accept the obscene chapter, is what you're saying.
That's what the courts would look at.
I'm sorry, I'm going to have to do more research and talk to our attorney because I plain flat don't believe you. Sorry, and I think your organization should be working both to promote intellectual inquiry for anybody of the age of 18. I have no issues with that. And age-appropriate inquiry, but what you've exposed us to is an entire school district basically subject to the whims of a librarian, and we have to tolerate it no matter what. So if I can, no matter, it's like a sandwich. As long as I put bread on either side of the sandwich, I have to eat the poisonous meat, is what you're telling me.
Do some additional legal inquiry if that is how you're feeling.
Well, we'll see, but I sincerely suggest that you're not liberty-oriented, you're a libertine-oriented society or an association. And if you care about the kids in Oregon and America, I think you better start working for them instead of against them, because the society, I will tell you this, venereal diseases are as dangerous as guns. Okay.
I have one more question that I'd like to ask, just so, would it, have you seen any schools that promote or have some sort of way to make sure that parents are notified when their child checks out a book of what books they're checking out, like kind of like on our Parent Square or something? I don't even know if that's like functionally possible with the library system. I imagine it could be technically pretty challenging, but I wonder if that could be like some action that we could take to promote like at least parental notification so that parents could have the opportunity to take an active role in seeing and observing what their children are checking out. Because where you lost me was the 0 to 17, and 17 is like we're talking, that's really tricky when you're talking about that standard and younger children or middle school libraries, and trying to work through that also. And I want to be respectful to you as a presenter. You came here to present information, and I hope, I don't think it's fair to attack you personally for that, whether or not we agree with your position. But I'm curious about the answer to that question.
Yeah, that's a great question. And I will sound a bit like a broken record. It would be questionable and a possible area where a lawsuit may come up. So from what we have in Oregon is that we have Oregon privacy laws that specifically say that library circulation records are exempt from disclosure. Ultimately, we also have FERPA that says that student records, educational records can be disclosed to a parent. So the question legally is, are library circulation records educational records, or are they library records? And there has not been a lawsuit that has been brought up in Oregon to define that. And so that would be a very big gray area on whether or not it would follow Oregon privacy law or FERPA to disclose the circulation records.
Thank you for taking my views, by the way. I like.
You're not the first one.
You're welcome. I am. I've read most of the cases, and I'm trying to find a reasonable way out, and I don't see any reasonable way out except for filing a lawsuit for declaratory relief, declaring each specific book we object to, probably in federal court, to determine if they're obscene. And that's the only way out, and that's incredibly expensive. But I will tell you this, the books, the intellectual inquiry you're discussing for people that are minors, like I said, I have no problems with adults. None. Offends the standards of our community. And we are the ones that have to face the brunt of that. I don't know if you face the brunt of it, but I'm going to have to go back and explain to the people who've elected me, we essentially have no control over what's in our library in terms of obscene content or obscene, yes, but R-rated, close to X-rated, we can't deal with it. And that's a bitter pill for my community to accept. And they're not going to be happy. And once again, in the big picture, this will lead to the continued deterioration of public schools. And so you can't change this. Maybe the Oregon legislature, if it changes its mind, can change it, or maybe the Supreme Court. But I don't think you're really understanding they used to call them, what did they call them when innocent people get killed in warfare? Collateral damage. The collateral damage of these opinions is substantial and significant. And I wish, nothing personally against you. I meet every time, I respect everybody's opinion, I'm fine. But the collateral damage is high, and in the long run, it's, I think, not intellectual freedom, but actually very bad. And that's my lecture, I'm sorry, for our school systems. And there's, essentially, you're saying that there's very little or nothing I can do about it, and I really don't like that, so therefore I'm pouting. Sure.
Understood.
All right, thank you, Emily. This, very informative, a lot of information for us to digest. I assume that the slides will be sent to the district, so we can look at the links and review the material ourselves.
That sounds great. Yes, and I will pass the slides along.
All right, have a good night. Thank you.
Thank you.
Goodbye, Emily.
All right, do we need a break, or do you want to keep pressing on?
It's up to you guys, I don't care.
Let's take 5. Yeah, so public comment at board meeting. Whose was that? Who taught? Maybe I wasn't there.
Last meeting.
There was a pretty broad discussion around public comment at board meetings at the last meeting, including like actually public comment about public comment. But I don't know it was actually me. I think it was more Pat that brought that. It was kind of both of us together and talking about that and the structure about that. I guess I'm not prepared to like lead this discussion.
No, that's okay.
One of the things Pat brought up too was holding more forum
Yes,
style
like a
meetings
town
with
hall type.
boards.
You made a brilliant suggestion. See, I can compliment people. And your suggestion is the meetings can go further. Okay, the comment sections we have in our meeting are too short. I try to give, if somebody asks questions or make an accusation and we can't respond in advance, or we can't respond at the time, it just makes people madder. You limit the time, it makes people madder. And then, see, these people are our shareholders. We have to respect our shareholders. They pay for the thing. So our business format is horrible for bringing up subjects and discussing them in any depth, because 15 subjects could come up, and I think it makes people angrier when they leave than when they come. And in public input's supposed to make people happy, or at least feel like they've been heard. So you made the suggestion that we separate the two and have meetings where people just talk to us, and we have meetings where we just do business. And we have to hold enough of them so the shareholders, the public that votes for our money, feels that they can get their questions answered in a reasonable manner. And once again, my poster child for this is the flags. The state of Oregon has determined it's the teacher's freedom of speech to put flags in the classroom. We didn't do that, and you would make the assumption logically that the school district would own the walls and the chalkboard, but apparently the state of Oregon does not. It was decided under the state constitution. Well, Newburgh decided to limit them, and each board member got sued $8,000. And the school is still paying off the judgment for restricting the teacher's freedom of speech. So there's things that we can't do, and I just use this example. But if somebody gets up there for 2 minutes and says, I hate this flag thing, Sometimes I'll break into an explanation, sometimes I won't, but I can explain that much better in a format that is just we're meeting there answering questions.
So-
So that is, I think we have to have a thing where we just, a meeting where people can ask questions and get answers and feel like they're cooperating. And the other thing we need to do at these meetings is what I have discovered, that the public does not know what a good job the school district is doing underneath its limitations. And they do not know what the teachers are doing or what the teachers actually need. So they insult the teachers get upset, and we have silliness. I think we should invite some of the teachers in so they can explain what difficulties have, what they need to get things fixed, so everybody understands each other. Nobody currently in this, we've got a public that is indifferent, angry, some supportive, and school people, and I'm sorry to be so kumbaya-ish, but once I've gotten this position and I've talked to our illustrious superintendent, and I think he has done an excellent job. He runs a very good machine. The school district is a machine, and the machine's supposed to turn out educated students, and that machine is paid for by the shareholders. Everybody's got to talk as to what they're doing and what actually you want to teach people better. Quite frankly, I've been here for a year, and I don't know what we need to teach people better.
So do you have a specific recommendation? Because you and I sit in your office and talk all the time, but what are we going to do as far as the board?
I think we have to invite the public in and find some way to have a meeting where we're just here and talking to the public.
What does that look like? What's the
I have an idea on this, and we've talked about this before. Essentially having zone meetings. So like Pat and I would meet the public at Hidden Valley, and we'd work out a time to do that, because I think it's kind of hard to herd the cats. And then Jen and Nancy would meet the public at North Valley or Fleming or whatever, and the superintendent would attend, and other guests would
And if
attend.
there's only two, it isn't a meeting.
If there's only two, then it isn't a meeting. And then Cameron, I'd probably come out and join you in the Illinois Valley. So we've talked about this. We just have to get it on. So what I would recommend going forward with that, and I think it's a great idea. I think we used to have a couple
great
town
idea.
halls.
Great idea. Great idea.
Hang on just a sec. We used to have a couple town halls as we go. So what we do is so for instance, Pat and I would work it out with Dave for a date, and Cameron, you would work it out for a date, and what works for you, and then we'll get a second board member there, and then you guys would work it out for a date. And then go around, and then that way we can kind of meet the people where they are without having a quorum, which would be, I think it would be a good thing. I think it would be good outreach for the district.
Because it's not working now.
So I think one of there are a few things that I like the idea of the town hall meetings with the local community and involving the zone representatives more closely with those groups. I think we have to be really careful when having dialogue back and forth that is never construed that one of us is speaking for the board.
Correct.
We are only speaking as our individual self, and then there needs to be some method of carrying the information or the sentiment from those local area meetings back to the board so that we can digest together what we have heard in our community meetings, perhaps and down the road may not be here, but won't be here. But in a group, maybe work session or something.
It could be a report item on the regular agenda.
Right, what are we hearing
Reports, right.
from our constituents in our district, and what kind of ideas or comments do you think we need to bring forward for potential board action? So I think that is really important. I thought it was interesting in thinking about making sure parents are heard, that we might put those parent comments at the Like, that is really important to hear from our parents or from our students when they're coming to our meetings, but they are not the only members of our community that are dedicated to our schools. So I think, but I really do want to make sure we're hearing from them because they're having lived experience in our schools right now. And then as it pertains to public comment, and I guess I was really uncomfortable in last month's meeting, and I think all of us can recognize the graphic content of the single comment that we received. What made me especially uncomfortable was that there were children, youth in the room for that comment. And actually, I was reflecting on this all month. More kids were probably exposed in that meeting to that content that also the board hadn't even had the chance to review yet, than actually in the district libraries being checked out because of how often that book had been checked out. Plus then it was shared and shared and shared. And I guess I have concern. I want people to be able to speak their minds, but you speak differently in church than you do. I saw this in an article that I read about it. And I thought it was an interesting reflection about it. You might watch an R-rated movie one night, but you don't speak that out loud at church. And I do feel like this is a respectful environment that we want to be welcoming to families that might be bringing their young children with them. And I don't want those people to feel like they have to leave the room during our public comment. So I guess I understand the reason why that comment was made, I think, to share with us sort of like how extreme the content is that we're talking about. But at the same time, like, I feel like there is a time and place, and I certainly would be very happy to receive and read that content myself. And also, like, the public comment is for us, the board, to understand what is going on, and there are multiple different venues for getting us that information, like email, they can call us, we have written testimony as well as that public testimony, and so I think there are multiple ways to get that here without potentially exposing younger children than we would want to certain types of material.
I'm going to be mean. I like your response, and I think your response is beautiful, and I think it's actually correct, but it's contradictory. They have determined that this content can go to any of our children without any parental supervision, and I don't think the public knows the nature and extent of what was read, and I was appalled by what was read, when even the Courier is appalled by what's read. So there is a problem here, and if our Supreme Court, if that's in fact the law, has determined that this article in this language is good enough for 8th graders, then it can be read in public because it shows the glaring contradiction between what they're saying and their care for our children and how it needs to be addressed. So read away. There's transparency here.
Well, I see that. However, it's related to a book that is under scrutiny now that has not made its way yet to this board, that is on its way to this board through appeal. And so I guess what I see what you're saying, but I also feel very strongly about protecting young children from that content, or the children that, like, the whole appeal is designed. So I wouldn't want to invite an elementary school classroom to be present at an award in our board meeting and have that public comment read, and I wouldn't want to feel responsible for being a person on the board that set that standard.
Well, I'm looking at it and I'm saying it's ugly, when there's no doubt that it was ugly. But that is, unless you expose ugliness, then people do not respond, and it slips out of consciousness and goes away. Whatever is coming to our kids should be able to be read at our meetings, and the people should know about it by the basis of transparency.
I fully agree.
And they cannot, no clapping, please. I got enough problems in life, but thank you anyway. But what you're saying is inherently, I love what you're saying, and I see sadness in your eyes, and I'm very empathetic for you, and I think you're a very smart woman. I'm going to miss you, because you've made many smart suggestions to me, which I backed up, and vice versa. Seriously, I will miss you when you eventually quit. But what you're saying is inherently contradictory, and it's disarming one side of the fight before it begins. People have to know. And I actually, my experience is different in the courtroom. I have to, all kinds of things are said. Children are allowed in courtrooms. Children are exposed to all kinds of things. But if what we're saying is, on the whole, we can't limit damaging material to children, and she said we can't, people should know that. How do they know it?
I guess I am still not okay with young children being exposed to that content. And I
agree
don't
with
want
you.
us to be the permissive place in the district, or the weak link to where children are exposed to things that are outside of what's age appropriate for them.
But that's our library that's doing that.
But we
which is
haven't
even-
had the chance as a board to review those materials yet, and we didn't select them.
Yeah, I'm
Chair.
gonna chime in here for just a second, and yeah, I mean, there's a, you know, I mean, there's a balance here. I know that District 7, talking with Gary, you know, keep the comments to the agenda itself, like what's on the agenda, vice, you know, using it to talk about something that we're not going to talk about that day, that the comments are, you know, it's unrelated to the topics that are at hand. And I think that's a decent policy. I also think, though, that, you know, I mean, a new school board will be here in July, and I think it would be an excellent topic to take up, you know, from a policy standpoint, you know, at that point. And then to be able to facilitate this, I mean, I think going back to the other topic is we have these conversations through town halls so that everybody can be heard.
Yes.
And maybe we make it a board goal. I mean, it's not a board goal. I mean, we're not doing a formal motion here, but maybe we can, you know, we're also in budget season, so I think it's a good time to hear the public. And, you know, maybe some other things will come up as we're getting ready to approve a budget. Maybe we set it as a goal that each area has a town hall before maybe May 15th. I mean, that's a month and a half. I think that's fair, and I'm not asking 5 people to work it out for a date that works for them. I'm asking 2, and then I'm telling the superintendent that, you know, we'd like to have you there. And so, does that seem reasonable?
I think that seems really reasonable.
But-
And go ahead.
You solved the problem, and we've solved the problem by separating the comments to the meetings. So we have that solved. I mean, it's so, and we should also, if somebody can't make a meeting, another board member should be able to fill in for another district, because what's important is the information gets to us, the information gets back to them in a complex way, not in a 2-sentence way, that we take some anger out of the community, because the worst thing we can do is ignore a community. Even if we have to give them the wrong answer, that's better than not answering them. And then we take the information back here and we do what we can with it as human beings, and with is in our conscience. But the culture war has come. I can tell that from it was a Courier in the headline saying former offices that nobody cared about are now being disputed, and the culture war is here, and we have to learn. Even I have to learn to be polite because I lose it sometimes. But we have to be able to get thicker skin, take in hard comments, and all learn from each other, or else we're not going to make it. And this is the best answer. Having the actual meetings where we actually talk to people in depth is the best answer I can come up with. And then our meetings are shorter, and not everybody has to show up here every night.
Well, I think we all have head nods on that. That's what we want to do. I mean, I can't take it to a formal vote, but does everybody agree that?
Yeah.
I mean, it would only kind of work if we had consensus. So, all right. Well, then that's what we'll do. moving forward without a board decision. Everybody wants to have zone meetings, so that's great that we'll do that way.
And all parents would be invited.
Anybody,
All-
anybody.
All community would be invited, and it would, you guys set up where you want to have it. Pat and I will set up where we want to have it, and Cameron, you set up where you want to have it, and I'll be there.
Sweet.
You don't even have to coordinate. Well, you kind of have to coordinate, but you don't.
It's,
Okay, so that's good, and I think that's a good way to do it, and then maybe, I'm not going to be on the board next year, but maybe moving forward, that kind of works itself into a best practice if it goes, going forward. So I think that's an adjustment we can make, and I think it's a good adjustment.
your legacy, Jennifer.
I think this is something that will be hopefully good. And then we'll need to make sure as a board that we receive the input that we need in a timely manner related to actions the board is taking. Because that's another important piece as well, if there is comment or input related to something that the board will be taking action on.
How about we try it once and see if it works? If it works, great, then we all claim credit. If it stinks, we'll do something
Yeah.
different.
And Jennifer won't be here.
We do things together, not as individuals, right?
If it stinks, blame me. I'm okay with that.
It's Rich's fault.
That's right. There you go.
It's,
There you go. Throw me under the bus. I don't care. So let's talk about challenge of instructional materials. And I'm at a loss as to when this was brought up, but I think I'll kind of lead it out because we're going to talk about. I think this was probably brought out into the challenge and where we're going to go procedurally.
yeah.
As the book challenges percolate up and go from there. So once they go to the committee, then they're going to either be removed or stay in the library. Then the complaint goes up to the superintendent. If the superintendent deems that the book is, then the complaint would come to us to go ahead and make a determination on a book.
Do we have a timeline for that?
Well, and this is what it depends on. I think there's a couple things that have to be looked at here. I think one, before the board would make a decision to remove a book, we would probably want a legal opinion on that, because now we are subjecting board members to a potential lawsuit.
100%.
And we're subjecting. So there's that part. I think the other part is if you're going to reasonably vote and apply, to remove the book, then you need to have a reasonable time to review the book. I think that wouldn't be due diligence with a potential lawsuit. I think that would be very bad. The other time, and so that would be, so what we would do is if a complaint is received, we'll put that on the agenda, and then we will prioritize the books and the process. I also think that it'll probably be it's not going to be, we'll probably have to do it as a special meeting.
Maybe.
To be able to conduct the district's business at the same time, because that could go for a while. So we would have to have a special meeting. We can talk about that as they come up.
Is there any, I don't know whether Dave or any of the staff has any input on that. I would certainly like to understand the legal framework into which we're operating, but is there any comments that you have? Any things that you think relative to this point?
No, I think it's just important that we follow the process that's in policy, and which we're currently doing. And then when it comes to the board, it's not necessarily the reconsideration of the material. It's now a formal complaint. And so we operate within that parameter of our policy. And that's been included in your materials too. And so I think the only advice I have for the board is that we follow the policy, because that's really the thing that
Well-
would come back. If we don't follow the policy, then
Okay,
whatever
that-
decision you five make.
I'm going to
Subject
add
to
this,
you.
where you get into trouble, because I've been a public attorney for a long time. If you have a procedure, you follow the procedure. Then nobody can criticize you. If we need to adjust the times, and we do have a procedure, and it's pretty detailed, and we might have to modify it to get the board more time to read the book, we can look at that. But the reason Grants Pass got in trouble is they didn't follow the procedure. They went straight to the library, if I remember correctly. And so we follow the procedure, and we have to follow it, or else we expose ourselves to a potential liability, and that's okay, we can deal with that. And then we have to follow the law, and that's what we're stuck with, whether we like it or not. We have to find out what the law actually is, and she may be right. And we may have little discretion in what we can include or exclude in our library, and I'm willing to accept that if that's a reality, and I have to deal with that. But that's so follow your procedure, follow the law, you got nothing to worry about.
So I have a quick question related to policy, and I just want to make sure that I am understanding the policy correctly, that there is a 30-day time frame for the initial review, but there is no specified time frame for the board's review. Is that correct?
That's correct.
Because that seems a little, that could be,
Well, it depends on any nature, that's any complaint that comes
okay.
in that part. So,
Oh, the complaint procedure. Okay, all right. I was just looking, I was trying to find a time frame to try to figure out like if we were within the time frame
yeah. as part of
currently,
that.
and there was nothing there, and I was surprised by that.
You know, a public complaint or a formal complaint could be anything like from a personnel issue.
On any law, the standard is reasonability. So we can't say 3 years from now we'll hear it. But if we have to read a book, we can say we'll hear it in 90 days or 60 days. And I think that can't be challenged. And so if wherever there's a blank, you can insert reasonable.
I wanted to ask, who selects the selection committee that
It's
vets
in
the
policy.
books?
It's written in policy, so it's the director of curriculum and instruction for whatever level that book was challenged at, which is Casey Alderson or Jessica Durant. So they build a committee based on what the policy says in that handout.
Is it an unbiased committee
It
by
certainly
chance?
is.
Because they unanimously voted for these X-rated books to stay in our schools and our libraries. So,
are
and
you
you're
calling
telling me,
them unbiased?
I'm
or
asking if
biased?
they're unbiased.
They're unbiased.
they're unbiased, based on?
Based on the select, they're professional educators and parents.
And they have constitutional standards.
And they unanimously voted to have these pornographic books in our schools? Is that what you're saying?
I didn't say that. I said they were unbiased.
I would call it R approaching X. And who selects the parents in the committee?
The director and the principal. Hey, you got a parent that'll come and do this.
Okay.
It's not like people are jumping up and down to volunteer to.
I certainly am.
I know a young lady personally, actually, that was involved in coming to the meetings and trying to make a difference and impact the school that her child attended and the community schools. And she just, it really took its toll on her health and her mental health. This is what she told me, because she was just being stonewalled at every, I can relate to what she's saying. She's being stonewalled at every turn. So, you know, it's nice that parents will hopefully get to be heard about their concerns about their children that come to these schools.
Agreed.
Otherwise, they're going to be pulling them out, and the schools will shut down. No one will care that they leak anymore.
And I don't want that.
No, we don't. I don't either.
I think it is certainly in the interest of this board, and the reason we are here is hopefully because we believe in our public school
Yeah.
system as a way to make sure that we have an educated public.
Yes. And we help everybody. We have, it just sounds terrible in terms of students, we have no standards, and that's a wonderful thing. So we pick up everybody, and everybody needs to be educated so they can pay for your Social Security later on, yes, as you slowly back out of the work process and finally leave this board. But it's just, at times I get terribly frustrated at the limitations we have. And remember, the people of Josephine County that vote are our shareholders. This is a corporation. We have a board. We have our executive director here, and we have a product which is educated children, and it's essentially a machine that we want to turn out wonderfully educated, responsible people. But everybody, the shareholders have to be heard, and have to be respected, and have to be explained to why we do what we do. Otherwise, we're going to have completely open roofs, because remember, they voted roofs for dogs before they voted for roofs for our children at the last election. So that's where we have to, I think, do better, and that's what I think the meetings are for.
All right, back off meetings, and now we're to flag displays and salutes, INDB. And so we approved the flag policy.
Twice in the last, 8 months.
515, it says we adopted 515.4, but I feel like we just voted on this one. Is it not included on here because we just reviewed this like 2 months ago?
Yes.
And approved it.
It is not back from the state yet.
Okay.
So also, I think what happened at the last meeting was explaining the Newburgh decision, and that the walls of the schools and the schoolrooms do not technically belong to the school, that the teachers have freedom of expression also. Every class, I believe, has to have a flag.
Yep.
And we're not required to even salute our flag under the law, because everybody has a freedom of speech. Most people do. I don't think that any teacher anywhere made anybody, at least in this district, made anybody pledge allegiance to the LGBTQ flag or a Black Lives Matter flag. So I think we're basically okay. I think we pledge allegiance to the American flag, and the teachers get their say because the state of Oregon said so. And I think that ends it, because that's as far as we can go.
Well, was there other concerns on the policy?
No, I don't think so.
Nancy, you're the one that asked for the policy to come back. Did you have any discussion for us on this one?
I just want to see a one flag policy in our classrooms and on our school grounds. It's pretty basic.
I came across an article that I did not send him while he was on vacation, because I respected him. The state of Utah has adopted a law that says that, but it's the state legislature that would have to change the law, and it might even require a constitutional amendment, because the Oregon Supreme Court interpreted the flag policy not on the basis of the U.S. Constitution, but the Oregon Constitution, which they have virtually exclusive control over. So to fix this is a political question. It's a question that we cannot answer, and I'm afraid it's a problem we can't fix without severe liability. So I think that the people who are involved in the political process has to get more involved. And that's the only way we can be saved. And I know that makes you sick.
I'm going to investigate more about the Newburgh case. I don't think it's as you said.
I'll give you copies. I've got a thing in my car of a collection
Okay, do you have
of packets.
updated information on
Yes,
that?
I have it in my car. I'll get it to you after we're done.
Thank you.
You know, I'm just thinking through this, and I can see where different flags can be a slippery slope. We could adopt a resolution that we send to the governor saying we wish you to review this, and at least make the district's stance known on that. Same thing with books.
We banned
If-
Confederate flags.
Yeah, but I think, you know, I mean, I think there's a part of me that's, you know, I mean, you know, the biggest part to me is the 0 to 17 that we were just briefed on. And so I think there's slippery slopes on a lot of this. And I think at least as a board, we could come out and advocate that, look, you know, you need to take action and kind of come up with a decent resolution, because I mean, we wouldn't, if we were to fight these lawsuits, we wouldn't have kids in school because we would be out of money.
Of course.
And so, so that's kind of just a thought of, you know, I mean, at least, you know, putting it out there that, you know, Three Rivers wants to, you know, I mean, tell the governor, look, this isn't appropriate, and, you know, you need to do something legally to, you know, provide us some sort of protection, so we can make better informed decisions. I think that's a reasonable approach, and maybe we can figure out what that resolution looks like, or what that letter to the state looks like that we voted 5-0 to, you know, look, you need to look at this, because this is, you know, this isn't really good.
There is a book called, I just heard about it today, it's called Worm Loves Worm, and it's written for 4 to 8-year-olds, and I hope we don't have those in our schools. I just heard about it today, and there's another book as well that I'm going to look up and bring up this evening.
Well, all I can say to everybody, thank you for putting up with me, because sometimes I lose it. Secondly, and these are hard questions, and it used to be that school board was the easiest job in town. Just ask our superintendent, thought it was a lot easier 5 years ago. But this is now a difficult job where we all have to search our consciences and bring up concerns that we have, and sometimes we're going to win and sometimes we're going to lose. But I think everybody here is sincerely attempting to do our best for Josephine County and all its students. And I'm always going to do this, is that we were talking about politics. I was going to compliment Dave. The school is a machine. The machine has hundreds of parts, hundreds of personalities. It has money issues, it has teacher issues, it has people have to get fed issues, it's got transportation issues. Facility issues. And he does, and I don't even know what his political point of view is. I've never asked, and I've never been able to figure out, like Walter Cronkite. He does a good job, and he runs the machine extraordinarily well. And when it comes to politics, to a certain degree, we're political because we're a board. It's our job to fight the ugly fights. It isn't his job to fight. His job is to keep the machine running as best we can with the resources he does, and he does an excellent job. And I certainly don't want to stress Dave out, because I like him here. And we'd have a hard time replacing him with anybody better. So he's running an excellent machine, and that's the way I grade him. What we can do with that machine is up to us, not him. And so thank you, Dave.
Thank you. Appreciate that, Pat.
All right, Pat. Superintendent evaluation number 2 is conducted, and I appreciate that.
I don't
though.
care. I said what I meant. Yeah.
So, public meeting do's and don'ts. I'm trying to figure out this is to do the ethics training.
Information for you.
So that is just for information that we all have to do the ethics training. Of course, your statement to the state of Oregon, or your OJEC, was it Oregon Governmental Ethics Commission submission, needs to be done by, that's coming up
Yeah, it has to be completed. Even for those of you that are leaving office this year, you will have to complete this training before that.
Is it online?
It is. I have linked it here in the agenda.
And how long do we have to do it?
You have until June 1st.
Okay. well,
So there's that, and then there's also the conflict of interest statements that go to the State Ethics Committee, and that's in your email. You've been probably emailed on that several times by the state of Oregon to complete that document.
And that one's April 15th.
And that one's April 15th. Of course, tax day. So you got two things to do on tax day.
Besides pay taxes.
Yeah, pay taxes and fill out your Oregon ethics. And they were going to do away with that for smaller districts, but they have not yet. So
I was doing a review. I have to do legal education, and I'm listening on new public laws, and it says districts that deal with $1 million or more have to take this. And I'm going, my God, this is from 2023. We haven't done it. We're all in trouble. And it's like, hey, I came running in and saying, we got to do this. And he says, it's on the agenda, Pat, settle down. It's okay.
all right, future meeting dates, 16th, we're at Hidden Valley High School. And we got student panel at 2, the meeting at 4. And that's where we're at. Work out and let Dave know where you want to do the community meetings at.
Yeah.
And let Jessica know, yes.
So it gets done right.
And then we will push on from there. And with that, we are adjourned.
Thank you for keeping me under control. I'm trying to. Trying is difficult.
I can, I mean.
My wife would have